Uh, it is my pleasure to introduce Commissioner J. Christian Adams. J. Christian Adams is the President and General Counsel of the Public Interest Legal Foundation. He served from 2005 to 2010 in the voting section of the United States Department of Justice voting section. Justice Adams was appointed by the President to the Presidential Advisory Commission on Electoral Integrity. President Trump also appointed Adams as a commissioner to the United States Commission on Civil Rights, where he also now serves with a term through to 2025. He's been involved in election lawsuits in 33 states, including the territory of Guam. He has represented multiple presidential campaigns in election litigation. He has a law degree from the University of South Carolina School of Law and is a member of the South Carolina and Virginia bars. Without further ado, I introduce Commissioner Adams.
Hey there, thank you all. Thanks for attending. Thank you for that introduction, and thanks for organizing the event. I always think it's great to have Federalist Society events touching on hot issues, right? And I can't imagine a hotter issue right now than the election. So what I thought about doing, I think that the title of the event is, is it best to have why does the Constitution and how does the Constitution view elections in our country? And I spoke at, where did I speak last week? At New York City, Columbia Law School. And I think that I had more questions than I had content. And so, I'm happy to take questions. I might not touch on something, but that doesn't mean you can't ask me a question about an election issue, because I do pretty much every aspect of election law. And we're, at the Public Interest Legal Foundation, we are a C3 that only does election law. And if you ever want to apply for a clerkship, please think about it, because we have clerks and we would be glad to get your resume. All right. So feel free to ask questions. I might not see a hand raised, but with some help, we can get your questions. So why does the Constitution matter in this space? What do elections have to do with the Constitution? And of course, the Constitution contemplated a federal role for elections that pretty much dictates so much of what's going on in this cycle, and that is the elections clause of the Constitution. There's actually an elections clause, and it says effectively that the states are in charge of their own elections. They get to set the criteria for qualifications and all of those things regarding elections. And Congress can step in at any time, and I'm using the actual words of the elections clause, at any time, to set the times, places, and manners, once again I'm quoting, of choosing members of Congress. So once again, the states have the default power, and Congress at any time can take away that default power and pass federal election law. Now, why did the founders do this? Why did they give the states default power, but reserve this really wickedly potent power to wipe out anything the states do? Okay, here's why. It's kind of funny if you look at it in hindsight. The founders were afraid that the states were going to suffocate the federal government. They were afraid that states wouldn't hold elections for Congress, right? And therefore, they would never be able to constitute Congress. And so they put this in the Constitution because the states were afraid of, the federal government, the founders were afraid of the states smothering congressional elections. Now, of course, that has not happened, has it? I mean, in fact, it's almost the other way around in some respects, that the federal government has become more powerful than the states. But why else did they do this? This is an important point. They knew that division of power between the feds and the states, as you see all throughout the Constitution, was a way to promote liberty. When you split power up and give it to the states, but sometimes the federal government can take it, you promote liberty and freedom. And they knew, based on what they watched in Europe, that if any centralized power, whether it's the King of Spain, the King of France, take your pick from their experience, the Emperor of Rome, they were looking at all these moments in history. If any one central power has a lot of power, they abuse it, right? So that's why the founders split up who controls our election. So the state of Colorado can pass all kinds of election laws, and they do. When are you going to hold the election? How are you going to hold the election? What do you call the clerk in charge? I think in Colorado, they're the county clerks. How did you have an elected Secretary of State like Jenna Griswold versus an electoral board like you have in South Carolina? Like all of these decisions are the state legislatures. But by golly, you're going to offer voter registration inside DMV offices in Colorado because that's the federal law called motor voter, which is a segue into the first law I want to talk about, which is the National Voter Registration Act. This passed in 1993, has a whole bunch of provisions, and it was passed under the Elections Clause. And it said basically that every state except 6, and that's a whole nother issue we'll talk about in a second, every state except 6 have to offer voter registration when you go get your driver's license. That's why when you go to get your driver's license now, or even update it, you're asked a bunch of stuff about registering to vote. If you were to go to a military recruitment center, of which I guarantee you there's one probably in a shopping mall within 10 miles of you, they have to offer voter registration services. All because of Motor Voter 1993 National Voter Registration Act. I do a ton of litigation in this space. We sued Colorado, as a matter of fact, because Motor Voter has a transparency provision. Transparency. In other words, if a state official like the Secretary of State of Colorado has what's called a list maintenance record, in other words, a document relating to removing and adding people from the voter rolls, keeping the rolls clean, it's public. You guys can walk into what county are you in? It's Boulder County, I guess. You can walk into the Boulder County Elections Office and say, hello, I'm a law student, and I'm here to publicly inspect your list maintenance records. Under the federal law, you have that right to walk in and start touching records. It's not like a FOIA, State Freedom of Information request, where you send a letter under FOIA and they have like 30 days to respond and they'll send it in paper and you have to pay for costs. No. National Voter Registration Act has a public records provision that allows you to go touch things. Okay, it's like a hands-on petting zoo where you can go into the records office and start looking at election records. And you don't have to wait 30 days. Now, you want to be reasonable. You don't, and we could talk about litigation in this space. I brought tons of cases from Alaska to Maine, Louisiana, New Mexico, Colorado. We had a case in Colorado against Jenna Griswold on this very issue. So I'm trying to impart that if you're looking for public records relating to the election, there's a federal provision that allows you to get it. Now, once again, just to go back, why is there a federal statute? Well, that's because the Elections Clause. And Congress decided to legislate in this very narrow area of public records about elections and make it public. I suppose that's a good place to say something about the whole space of elections law. Guys, all of you are, and gals, all of you guys are interested in whatever topic of law you might want to do after law school. I get it. I was there too at one point. And what I just want to explain is elections litigation is an incredibly growing industry. Okay. You could almost make money right out of law school just by doing public records cases, right? Low overhead, attorney's fees provisions. I mean, we just got a check this week from one state in the Northeast for $150,000. Pennsylvania is going to owe us hundreds of thousands of dollars because they didn't turn over records. but that's the boring part of election law, right? A records case. There's all kinds of other election law. I mean, you guys had a ballot access case involving Donald Trump in Colorado that went the whole way to the Supreme Court. And if I remember correctly, might have been close to 9-0 or 8-1. I can't remember the exact number, but it was overwhelming, right?
I believe it was unanimous.
Okay, right. Okay. Yeah, it was. It's so rare that that happens in a highly controversial case. I was reluctant to go out on the limb, but you're right, it was unanimous. A lot of the lawyers on that case, I know, one was a former Secretary of State of Colorado, Scott Gessler. You ought to call him if you're interested in this area and say you want to clerk for him. He's in Denver. He was one of the litigants in the case, a ballot access case involving who gets to decide who can be on a federal ballot. Is it the Constitution or is it Jenna Griswold? And the 9-0 Supreme Court said that only the Constitution can set the eligibility requirements for running for president, not the Colorado Secretary of State. So, you guys have cases in Colorado even in election law. But what I'm trying to tell you on this point, there is a ton of work here, right? And it's fascinating work. Sometimes it's high pressure work, like this week. I mean, I don't even want to think about it. I can't believe we scheduled this event this week. You get to argue in the courts of appeals. We're in the Fifth Circuit this week or this year. We won a case there on the Voting Rights Act. We're in the First Circuit. We won a case, I think, this year on the National Voter Registration Act. We argued in the Third Circuit in Philadelphia about 2 months ago on what records or what does the National Voter Registration Act address. We're doing an appeal in the Ninth Circuit from Hawaii. We have a case in Hawaii. The point is there's tons of work here, and I'm just scratching the surface. Okay, let me look at my notes. Oh, okay, I'm going to give you a hypothetical hot case out of Pennsylvania. So in Pennsylvania, when you want to vote a mail ballot, you're supposed to date it and put your signature on it, okay? And a lot of voters are not putting their signature on it and the date. And this went up to Justice Alito out of the Third Circuit on a materiality provision. Materiality is in the Voting Rights Act, the word materiality. And you can't deny somebody from registration for not including a non-material bit of information, like a T being crossed or an I being dotted. In the South, voter registrars used to deny African-American registrations because they forgot to include like a dot or something silly. So the federal law under the Voting Rights Act, passed in 1965, says you can't exclude somebody from registering because of a non-material issue. Well, back to Pennsylvania. People weren't putting their date and signature on mail ballots. And some people were saying, well, that isn't material. You shouldn't have to do that to cast a ballot, even though it's in the state statute. Well, it went to the Third Circuit, and the Third Circuit ruled the materiality provision of the Voting Rights Act only applies to registration, not to voting. That's the holding. Registration, not to voting. And so when it comes to casting an absentee ballot, the Third Circuit said, if you don't have the name and signature and date, they can say the vote doesn't count. And it went up to Alito for a stay, and he rejected it. And so the Third Circuit ruling applies from the Third Circuit. So fast forward to 2020. That was last year, last election. Some states or some counties, strike that, in Pennsylvania, some counties were allowing voters to cure their absentee ballot. So they would forget to put their signature and date, and it under state statute, technically the ballot should be rejected. But some counties like Philadelphia, and I'll just be plain about it, the blue counties, were allowing voters to cure their ballots. The red counties Lancaster, Westmoreland, Butler, Washington, around Pittsburgh, were not allowing the voters to cure their ballots. They were following the state statute. So do you see what this sets up? So my question to you guys to ponder, and I don't have an answer, I can tell you the Supreme Court did, is it better to have some counties following the state statute, the law, but not all counties? Or is it better for the state Supreme Court to say it has to be uniform, but everybody gets to cure contrary to state law? And that's exactly what just happened in Pennsylvania in the last 2 days, is this issue came up. And the Supreme Court of Pennsylvania ruled uniformity and curing. In other words, it has to be the same in red and blue, but we're not going to follow the state statute. So I don't know. I was about to file an amicus brief in the case saying there needs to be uniformity, and I'm not going to answer the question of which way that should go. But these are the real issues that are affecting the election right now. A brief comment about state statutes. Some of you might have been tempted to say, well, curing seems fair, right? You should be allowed to cure your ballot if you send it in with a mistake. What if there's a state statute that specifically says you can't? Like the case in Pennsylvania. What role does fairness play when the Democratic majority in a legislature passed a rule, right? That's an anti-democratic ruling by the Supreme Court, because the Democratic majority that was elected and given power to write the rules ahead of the election decided that they weren't going to follow the rules. To me, that's anti-democratic and violates the principle of democratic decision-making. What if in the middle of the game in the Super Bowl, or last night I was watching the Steelers-Giants game, what about at halftime, the referees say, okay, a first down is now going to be 15 yards for the second half, right? Well, wait a minute. We set the rules in advance, didn't we? Yeah, but we decided it's 15 yards now for the second half. That to get a first down, you got to get 15 yards. Well, isn't that anti-democratic? Now, I'm not saying the NFL is democratic, but you get my point. A democratic body enacted the rules ahead of time, and a court changed the rules in the middle of the game. This is a giant issue that's affecting the country. Like, should fairness trump a democratic decision? Should what seems good at the time transgress against the decision of a legislature? And then there's a whole federal interplay too, materiality, which I gave you a taste of. So that's a really hot button issue. And should fairness trump the law? I mean, I know where I stand on this, but okay. So some other hot issues going on in the election this year. There's a lot. Another one is voter removal programs. In other words, if you're on the voter rolls, how are you, like, what if you die, move away? We have a case in the Sixth Circuit that we've briefed that hasn't been decided yet on how far does the federal law go in requiring clean voter rolls. The National Voter Registration Act that I started this out with, guys, has a provision called Section 8. It says voter rolls, states must have a program to keep them reasonable program to keep them free of the dead and ineligible to vote who moved away. Let me do it again. States must have that makes a reasonable effort to remove the names of the dead and those who have moved away. That's a federal obligation. Reasonable. Now, if you guys had torts yet, which I assume you all did, you know the word reasonable is like a magic word, right? Reasonable. Because it doesn't have a definition anywhere, does it? It's not defined in tort law, except, some cases say, like, what would a reasonably prudent person do? A common man. I mean, you know this from torts. It doesn't have a hard definition. So the federal law is the same way. It doesn't define what a reasonable effort is to keep the voter rolls clean. So that's what our case in Michigan is about. to try to get some standards as to what constitutes reasonableness. But I'm telling you guys, this is a huge issue around the country because a lot of states, and this is right in front of the Supreme Court right now on an emergency petition by Virginia, a lot of states have removed people from the voter rolls inside a 90-day freeze. States cannot do list maintenance 90 days out of a federal election, except for the dead, except for the insane, that's in the statute, except for people who want to be taken off the rolls in writing, and corrections, which is totally undefined by the statute. Unless you're dead insane, you write a letter saying, take me off the rolls, or a correction not defined by statute. States cannot do any voter roll cleanup within 90 days of an election. Well, guess what happened this year? A whole bunch of states did voter roll cleanup within 90 days, removing non-citizens. That's what's going to the Supreme Court right now in Virginia, is can Virginia remove non-citizens or purported non-citizens, because I can tell you they're not all non-citizens, within 90 days of a federal election. This is affecting Colorado too. Colorado, you have a lot of very hot election issues there too. So this 90-day provision is not some theoretical thing you're reading about like antitrust, rule of reason or something. I mean, it affects your voting rights. Okay, I want to talk about a principle of equal sovereignty. It's another case we have. Can you think of an area of law where Congress can include some states and not others? Like, we're going to exempt Colorado from anti-discrimination law. Like, you can discriminate in Colorado. This law doesn't apply to you. Okay, that sounds crazy. I get it. That's my point. Under the National Voter Registration Act, you might remember I said 6 states were exempt. 6 states are exempt from the National Voter Registration Act. They don't have to comply with any of its provisions: transparency, voter roll cleanup, motor voter registration, DMV registration, none of that stuff. In fact, if you move wherever you're registered to vote, if you were to move a block away where you live, assuming a block away doesn't cross a county line, if you move a block away, under the National Voter Registration Act, states are required to automatically move your voter registration to your new address. They have to monitor this on their own. And if you pick up and move within the county, the state has to automatically move you to your new address. And you don't even know it. You say lift up your voter registration and drop it in the new address. That's a federal mandate. Okay? Well, 6 states are exempted from that federal mandate. Here they are. New Hampshire, Wisconsin, Minnesota, Idaho, Oregon, and this one's relevant maybe for you guys, Wyoming. Those 6 states do not have to comply with anything in motor voter that I've described. And you ask why? Because when the law was passed in 1993, those 6 states had same-day registration, which I think Colorado now has. Like, you can just walk into the polls and register and vote on the same day. And Colorado is still subject to motor voter. So we filed a lawsuit in Minnesota and Wisconsin seeking public records under NVRA to try to have those 2 states brought under the NVRA for the disclosure transparency provisions. It was argued in federal court 2 weeks ago. And you might say, what's your theory on that case? I would turn your attention to one of the biggest voting cases ever. It's called Shelby County versus Holder. It's complicated. I'm not going to have time to tee it up and set it up factually. But suffice to say, taken on faith, 16 states before Shelby had to submit all of their election law changes to the Justice Department under the Voting Rights Act to be approved before they could go into effect. You might not have encountered this if you come from Colorado, because the closest state to you subject to this requirement was South Dakota, California, Arizona. Those states had to submit every election change to the Department of Justice, where I used to work inside the voting section, to be pre-cleared. The Supreme Court in Shelby County versus Holder in 2013, you should read this opinion if you just want to get a whiff of election law. It's a huge decision, probably the biggest decision in the last, 15 years in election law. The Supreme Court said, no more of this, struck down this regime of preclearance, and said that current circumstances in 2013 no longer match the 1965 circumstances that gave rise to the Voting Rights Act, that gave rise to the preclearance obligation. Now, those of you who know what the rational basis test is and the broad deference to congressional power are probably saying, well, how on earth could the Supreme Court strike down this Voting Rights Act because it was no longer updated? Like, that doesn't, like, the National Labor Relations Act is like from 1936 and no one's challenging it. Or the antitrust statute, I forget the name, it's not Smith. Anyhow, the antitrust law is from like 1912, right? There's laws on the books that are really old. No one's challenging. And I'll sort of close with this, at least open up to questions. The Supreme Court held that when it comes to elections, and this takes us right back where we started, folks, who controls? The states. The states have the presumption of power over elections. And so when the federal government jumps in and takes control from the states, there's a lot of constitutional issues implicated. And courts are more reluctant to examine those intrusions into state law carefully and potentially strike them down like they did in Shelby, because it involves a power of the states, right? The founders wanted the states to have the power, not the federal government. So if the federal government takes the power, not only has it got to be based on a constitutional provision, but it has to also match current circumstances. And this ought to give you a lot of ideas about areas you could potentially practice law in, because, election laws govern school board races, county council, state legislature, U.S. Senate, congressional, presidential. The world got turned upside down 4 years ago in this space. And it really is just a big opening for young lawyers to come in and find a career. If you're interested in it, I would just encourage, get a whiff of it, because it's fun, it's academic, it can be lucrative if you play your cards right, and it's intellectually challenging. So, look, I'm gonna stop at 28 after here, because people often have questions, but if not, thank you all very much for your time.
Thank you. Do we have any questions? All right, well, if nobody else does, I've got a question myself.
Okay.
Going back to the overturned decision from Colorado to bar Trump from the ballot, do you think that this, in terms of election law, this might be a sign of things to come down the road for future elections, especially given the fact that I think basically since the Bush election, every single election has effectively been contested by the opposing party?
Yeah, so remember the basis of that, and that is that the criteria for running for president is set by the Constitution, not by the sort of the whims, and that's not the word in the opinion, I don't think, but the whims of election officials. This gets to the issue of following the law that I talked about. There's a huge opening for litigation for lawyers, and I've done it in places. When the law is not followed, you come in and you bring a case to challenge the failure to follow the statute, right? So yes, I think you're going to see examples in the next 2 weeks of, hey, you didn't follow the law, or these ballots didn't follow the law, and then the counter pleadings, right? so, yes, I think that court decision by the Supreme Court will at least have the effect of elevating the importance of what the decision rules are. The decision rules, in other words, what governs the outcome of a dispute. And in the case of the Colorado case, it was the Constitution itself.
Thank you.
Oh, and listen, Adams at publicinterestlegal.org. If you're interested in this area and want to clerk, we always have work to do. So feel free to zap me an email.
Fantastic. Thank you.
Thank you all.
Thanks for your time.